Hi there and welcome to Employment Hour in 30. I'm John Scholes. He is Lior Samfiru, the guy that really needs to be here. If you haven't caught the show before, we talk about your workplace rights, employment law, things that affect your job. Pretty much, I guess, on average, 8 hours a day for most people for 30 years of their life. So this is a really important show, the topics we cover. We'll talk about your severance, we talk about workplace rights, we talk about the ins and outs of having a job in this country and, coping with things every day that come up in legal terms. But we always like to start out the show, Lior, with a little segment we call The Week That Was. What's been going on in your world?
Well, what's been going on, John, is I've been talking to people, I've been emailing with people a lot of time, every single day about workplace rights, about their jobs, about the problems that people are having. People oftentimes proceed to ignore problems because they think there's no solutions. The problem with that is if you ignore a problem, it doesn't go away. It gets worse. It gets much worse, and oftentimes people say, well, I can't deal with it, I'm quitting, I leave, and they walk away thinking that there's nothing that they can do. Well, that's what this show is about. That's what I do in my job when I'm not here on the air, is I talk about workplace rights, I solve those workplace problems. So if you have a situation at work, something that's bothering you, something that's happened to you, and you're not sure what to do about it, well, tune into us right here, right now, and every week we'll talk about those situations. And of course, call me at the office or email me, we'll give you that information throughout the show. And to start us off, Johnny, let me tell you about a matter that came across my desk just a few days ago. I spoke with a lady that had worked for a company for a number of years. She was let go, but for the first 3 years she worked for the company, she was what they called casual. So she wasn't considered by them to be a full-time employee. That said, she still worked consistent hours. She worked about 15 or 20 hours every single week. After 3 years, she became, according to them, full-time. She started working more hours, and she worked there for another 4 years full-time. Well, she recently was let go because of a restructuring, and when the company decided to pay her severance, well, they have to pay severance, they said, well, you're a 4-year employee, so we're going to pay you severance as a 4-year employee. She called me and she wanted to know, is this right, or should I get credit for the time I spent previously, the first 3 years? Well, the answer is clear and it's easy and it's obvious. Of course they have to give her credit. The fact that she was called casual doesn't mean anything. Here's the bottom line, John. A company can't eliminate seniority or disregard service by giving you a title. Doesn't matter if your title is casual, part-time, on contract. None of that matters. If you have a job, that time that you have a job counts towards your service, and that's especially important when it comes to severance, because obviously the more service you have, the more seniority you have, the more severance you get. And I see this all the time. Companies thinking that they don't have to consider the initial part, maybe because someone was on contract or casual or part-time. No, it all counts. So if you lose your job, the entire time that you've spent with the company counts towards your service. So for her, I assessed her as being owed about 8 months severance. They offered her half of that. So the good news is I'll be able to help her. So for everyone watching right now, remember, don't assume that you get less credit, and if you had a job, you worked even in the past, that should count towards your service. You know, it's funny, we've talked to listeners on the radio show about this very thing. We've had people that have been 16 years casual or contract, 2 years full-time, and they end up getting let go for 2 years severance. You're like, no, it doesn't work that way, number one. Number two, if it was just that simple, wouldn't every employer do it? Exactly. So, I have 50 people working for me. I'll just call them casual. Here's the thing to remember. The law doesn't really care about titles, okay? Because anyone can have a title. Sure. The law looks at substance over form almost always. It looks at the reality. So if the reality is that I have a job, it doesn't matter what my job is being called by the company. If I have a job, I'm an employee. If I'm an employee, that time counts towards my entitlements. It counts towards my service. So I want everyone watching to remember that. 1-855-821-5900. That is a perfect way to get a hold of Lior and his crew anytime when we're not on the air here. EmploymentHourTV.ca. That is a good resource for all things about employment law. And you will also find links and ways to find our radio show, which we've been doing for over half a decade now, coming up on 6 years, I think. On those radio shows, always a ton of phone calls, people interested in getting their rights sorted out. So we'd like to get to a few calls on this show every week, play them back, and get you to comment on them.
This company that I work for, it's laying quite a bit of us off, right? I've been with the company for 25 years. My salary is around $96K a year. So I got a 20-week working notice and no benefits whatsoever after that. I'm 50. I am a computer programmer.
So the question really boils down to, is 20 weeks of working notice Is that sufficient for a 25-year employee? Well, the answer is absolutely not. It's not even close. But what is this idea of working notice? Working notice is a period of time that you have to find another job. You give advance notice of the termination of your employment. Now, if you do get working notice, that does count towards your severance.
Okay.
So if you are owed 8 months severance and you get 6 months working notice, that 6 months counts towards your severance, but you still have to get the difference by way of severance. So this person is owed a heck of a lot more than 20 weeks. So I can tell you how much he's owed, but let's use the severance pay calculator website so everyone can see how they can find out themselves. So if you were to go to severancepaycalculator.com and input this person's information, computer programmer, 25 years of service, age of 50, the severance calculator would correctly assess him being owed right around 18 months of severance. 18 months. Okay, so unless my math is wrong, that's 78 weeks. He got 20 weeks of notice, so he's still owed another 58 weeks of severance. So at his compensation level, that's a difference of over $100,000.
That's crazy.
$100,000. So if he had gone to the Ministry of Labor website, they would have said, yeah, that's enough, except that's not enough. His full entitlements are going to be much greater than that. So it's based on your age, position, and length of employment. So while the 20-week counts, it's not even close to being enough. He's owed potentially another $100,000.
Is working notice good for the fact that during that notice period, I guess you're still employed, you're still making money, still getting all your benefits, but you have the benefit of possibly going out and searching for work when that notice is over, right?
You know, it depends on your perspective. Some people would say it's easier to find a job while you're working, so I like working notice. Others would say, hey, if I'm going to get paid, I'd rather sit at home and get paid rather than have to work. So this depends on your perspective, but the bottom line is it is legal. It is legal to give working notice, except it has to be sufficient notice, enough notice. And in my experience, in the vast majority of cases, when the employer gives working notice, it's not even close to being enough, just like the situation we just talked about. And if it's not enough, the difference has to be made up by way of severance.
We'll get to another phone call, but I'm imagining when it comes to working notice on this particular call that as an employer, I wouldn't want to go too far in the notice because there might be a disgruntled employee, there might be some bad blood if you have them hanging around for 6, 7, 8 months and they know they're out the door, right?
Most employers don't like working notice. They don't like to have people around once they've been told that they're going to lose their job. Right. That's bad for morale. There's other issues. So you don't see that often. But if an employer does feel comfortable doing that, they're allowed to do it, but they have to give sufficient notice.
Severancepaycalculator.com. We did run through it here once. We'll get to it in more detail a little later on the show. 1-855-821-5900 to contact Lior and the rest of the team, and employmentourtv.ca. I think we got time for another phone call before we move on, so we'll get to another one.
Suppose you're working in a company for 6 years. You had a great business, whatever is working. Now we had a kid. I worked 2 days in the company and the rest of the 3 days at home. I had reduced hours, but that was okay. That was acceptable. Now say they want to ask you to come back more hours in the office. And you've been doing this for 3 years now. What if you say, you know what, I don't want to go this way. I just want to leave. Do you get any severance at that point?
Very good question, and we've dealt with this before on our various programs. So if you're working from home, that's an important part of your job. It's an important term of employment. You work from home, that gives you a lot of flexibility with your family, so that's an important thing, which means if your employer wants to change that, that's a big deal. So an employer is not allowed to change significant terms of employment. And obviously telling you that instead of working from home, you're going to have to work in the office, it's a big deal. So in this situation, this would be what we call a constructive dismissal. If his employer is insisting, if his employer won't back down on this idea that instead of working from home, you're going to work in the office, he would have the option to treat that as a termination and get severance. Even though he'd be quitting, he'd be getting severance. So no, the employer can't do that. And this doesn't just apply to working at home versus working in the office. It applies to any significant change. It could be a change to your job responsibilities, certainly a change to your compensation, to your work location, maybe the office relocated. Any significant change like that may give rise to the employee being able to say, no, that's a constructive dismissal. I'm going to leave with severance. So I would tell him, give me a call. Let's talk about exactly what you're owed, because no, they cannot just tell you instead of working from home, you're working in the office.
Is there any, and what are the pitfalls of just going along with it and accepting it if you choose to? Or out of ignorance, you don't know to do anything else?
Yeah, well, if they say, okay, tell you what, employee, instead of working 3 days from home and 2 days in the office, work 2 days from home and 3 days in the office, so he'll agree to a change by allowing them to make that change, he's arguably given them the right to do it again and again and again. So next time when they want to change it to full-time in the office, he may not be able to do anything about it. So whenever your employer starts changing the terms of employment, you got to hit the brakes. You got to stop that process, because once that train leaves the station, it's very difficult to stop it. You only have one chance to say no, it's a constructive dismissal. If you don't do that, you'll find yourself as giving your employer carte blanche to do whatever they want.
I would imagine the vast majority of our viewers are hearing that going, yeah, but I like the place I work. I want to be a good soldier and muck in and do what I'm supposed to do. Can they take it for a spin for a couple of weeks and see how it works and then still pull the plug?
Yeah, they can, as long as they make it clear that that's what they're doing. So to go back to the call that we had about the person that's going to be working from the office, he can say to his employer, tell you what, employer, I'm going to try it for a few weeks to see if that works for me, if it fits within my lifestyle. And I'll let you know after those few weeks if that's workable. So he can take it for a spin, as you say, as long as he said that that's what he's doing. And after a couple of weeks or so, he can decide, yes, does he want to continue that or no? And then he'd still be able to say constructive dismissal, but you have to be clear with your employer that that's what you're doing.
1-855-821-5900, a great way to get a hold of Lior anytime when we're not doing this TV show. We always pick a topic every week and go through some points on it. I know you like to expand on it. This one's a beauty, and I know you've heard them all. That is ridiculous allegations of termination for cause. Tell me about it.
So let's be very clear. It's difficult to terminate for cause. It's extremely difficult to terminate for cause. What I mean by a termination for cause, of course, is a situation where the employee supposedly did something so bad that the company can let them go without severance. Well, it's very difficult to terminate for cause, and even in situations where the employee actually did something wrong, in most cases it's not quite bad enough to be cause. But with that said, I've come across a number of kind of ridiculous situations where it made me shake my head for the employer to even try to allege cause. So that's what we want to talk about.
Number one is a beauty. This, I guess, focuses a lot on the salespeople. That is, the employer changes performance targets and then fires the employee for bad performance.
Yeah. So the employer moves the goal line and says, well, instead of having to achieve this target, you're going to have to achieve this target. And when the employee is not able to do that, they say, well, you didn't achieve the target, so we're letting you go for cause. Can you imagine if an employer can actually do that? That would be ridiculous. But that's exactly what happened in this case that I dealt with. The employer imposed these crazy, ridiculous targets. The employee, not surprisingly, couldn't meet them. And then the company said, well, that's bad performance. We're going to let you go for cause. So here's the thing. Even if it was bad performance, it still would not be bad enough to be cause. But beyond that, the company can't do something to you and then blame you for not being able to keep up. That doesn't work that way. That was a ridiculous allegation of cause. So if you're a salesperson, you're any job where you have targets, if those targets are changed unreasonably and you can't meet them, you cannot be let go for misconduct because you've actually done nothing wrong.
What does the employer have to do? Give you a little helping hand, give you a roadmap how to achieve it?
Well, frankly, if the employer is going to increase your targets, they need to give you the means to meet those targets. Maybe they're going to give you more clients, more leads, something. Right? They'd have to show that you are the one that made a mistake, and that's why you didn't meet the targets. Beyond that, just to say, well, instead of selling $100,000, you have to sell $300,000. Oh, you didn't do it? You're out of here. It doesn't work that way. It's never going to be cause. That would be a wrongful dismissal.
Ridiculous allegations of termination for cause. Number two, an employee did not provide a medical update from their doctor the very same day they were asked to provide one.
Case of mine where an employee got a letter from their employer. They were off on a disability leave, and the employer said, we need an update from your doctor tomorrow, except he got the letter that day, so it really had to be the same day. Well, John, if you've ever been to a doctor, you know you can't get to a doctor the same day you're calling the doctor. It takes a few days. So when he got them the letter, which was a few days after that, they said, no, we asked for it last week. You didn't give it to us, so you're fired for cause. Ridiculous. An employee should update their employer about their medical condition. And if the employer wants an update, they should ask for it. But they have to give a reasonable time for the employee to comply with it. You can't ask for an update the same day or within 24 hours or else.
Right.
It's ridiculous. It's inappropriate. In this case, potentially, it's also a human rights violation. So being reasonable is very important.
Ever have any issues with the stuff we're talking about or other things when it comes to your job? 1-855-821-5900, employmenthourtv.ca. We're talking about ridiculous allegations for termination of cause. We've either been through this, everybody who's watching, or you know someone who's been through this one. They missed a work shift because of a canceled flight. Out you go. You got fired.
Real
for it.
case, this person was a chef at a fairly well-known restaurant, and he missed a flight. Oh, and he didn't miss a flight. The flight was canceled because of bad weather where he was somewhere in the Caribbean. So he couldn't make it to his shift. He's in the Caribbean, couldn't call his employer. Came in the next day, showed up to work and said, well, you missed the shift there. We're letting you go for cause. And even when he explained it to them why that happened, the flight got canceled. Said, we don't care. That's on you. So you missed a shift. You're out of here. Ridiculous. What did this person actually do wrong? It's not his fault. He didn't just decide to go spend time on the golf course instead of going to work. It's an act of God. An act of God that impacts your job is never going to be cause. That employer was overreaching. It was illegal. Again, a wrongful dismissal.
Plus, he probably slid in another mojito before he got.
Maybe a couple, but we won't talk about that.
Ridiculous allegations for termination of cause. Number 4 is the employee did not pass a test. I'd be gone.
Yeah, you haven't passed the test in about 25 years, John.
That's right.
But here's what happened here. The employer decided that they want all their employees to have a certain level of certification. Fair enough.
Yep.
And this person had to write a test to get that certification. She wrote the test once, couldn't pass. She wrote it 3 times, didn't pass. Well, the company said, okay, you can't pass this test, so we're letting you go for cause. Somehow, they were suggesting that that's misconduct. That's ridiculous. Unless they were to show that she tanked the test on purpose, which is not what happened clearly, then it's not cause. So again, silly. You can't really be faulted for things that are out of your control. Okay, in this case, you do your best, you don't pass the test. It's not cause because you really can't control that. It's, again, an employer overreaching, an employer not understanding their obligations. Just a good example of some of the things that you may face with your employer alleging that they have rights to fire you when they don't really.
We've actually had to trim this list down to 6 points because there's so many of them, but we'll get to another. Ridiculous allegations of termination for cause. The employee, this goes under the don't mess with mama file. The employee did not disclose on time that she was pregnant.
So this young lady that was fired for cause, one of my former clients, she told her employer after about 6.5 months of being pregnant that she was pregnant and she's going to be going off a couple months later for maternity leave. An employer got very upset. It's 2.5 months. It's not enough time. It's irresponsible. You clearly don't care about the company. So we can't trust you anymore, so we're letting you go for cause. Silly, ridiculous, but illegal as well. You cannot let someone go because of when they tell you about their pregnancy. There's no legal obligation to tell the employer after 3 months or 4 months. The employee can tell them when she is ready. And the fact that they let her go because of pregnancy, because she's going to be taking a maternity leave, that's a human rights violation. That's illegal. So that employer, I can tell you that right now without getting into too many specifics, ended up having to pay quite a bit of money here to make up for that mistake. But I want to make it very clear here, you cannot be punished in any way because you're pregnant, because of when you choose to tell your employer about that pregnancy. That's a personal decision and no one can question it.
Get to one more of these ridiculous allegations of termination for cause. This one's some of us are like, I don't understand this one, why they wouldn't go. But the employee would not attend after-hours events and with the boss and coworkers because of family commitments. So they had to bail out.
And not everyone wants to socialize with their coworkers. You don't have to. It's not an essential terms of your employment. And this particular person didn't go socializing, drinking with the guys, and hanging out with the guys after work. He had a family. He wanted to spend time with his family. Well, he was fired for not being a team player, not being someone that wants to be part of the team. Ridiculous. You cannot be let go because of off-duty conduct. It had no impact on the job. So I brought this up here to make the point that if you do something off work or you don't do something off work, that's not going to be grounds for cause. That's ridiculous. That's a wrongful dismissal if I've ever seen one.
Still lots to come here. We'll get to the severance pay calculator as well, the problem with employment contracts, but we're going to take a short break. 1-855-821-5900 and employmenthourtv.ca as well. More Employment Hour in 30 is on the way. Don't go anywhere.
Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact: the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Welcome back. Employment Hour in 30, 1-855-821-5900. Anytime you want to get a hold of Lior and the rest of the crew, employmenthourtv.ca. Want to talk about the severance pay calculator. This is a very, very important tool, right?
Over 550,000 people have used it successfully. That tells you pretty much what you need to know. But if you're new to the show, you don't know what it is, severancepaycalculator.com. Again, severancepaycalculator.com. It's a tool, it's a website that I created to allow anyone and everyone to find out what is the amount of severance that they're owed, so that you don't have to call a lawyer if you don't want to. So you don't have to worry about, whether my offer is right or not. You can find out by going to severancepaycalculator.com. It takes seconds. You answer 3 simple questions about your age, your position, and the length of your employment, and then you're done. It's completely anonymous. It's completely free. You can't pay for it if you tried. Don't try. People have. It's free, and it's accurate. So if the first place you go to if you lose your job, severancepaycalculator.com, and if you're not checking it out because you think you think it's a week per year or 2 weeks per year, you have a bit of a surprise coming. Check it out right now. Let me know if I got you on this. Severancepaycalculator.com.
I know, in addition to all the phone calls, you get there's emails as well. You can send one anytime, help@employmentlawyer.ca. That's where we got this from. I'll read it to you. It has to do with the severance pay calculator, and I know you want to get around to answering it. It says, I was called into the boss's office and dismissed from my position without any notice whatsoever. The new owners said they couldn't afford me anymore and offered me only 2 weeks' pay after 9 years of hard work managing a successful team. I just filed a claim with the Ministry of Labor. Should I contact an employment lawyer instead?
Well, I have good news and I have bad news. Okay, and unfortunately the bad news are really bad. So the good news is, of course, this person is owed a lot more severance. We'll talk about what that is in a second. A lot more severance in 2 weeks after 9 years. But the bad news, which is going to be ultimately what this ends up with, is the fact that he filed the complaint with the Ministry of Labor. He is now barred from actually being able to pursue his full entitlements. The Ministry of Labor can only get him his minimum entitlements, which could be as little as 8 weeks' pay. His full entitlements are a lot more. So let's use the Severance Pay Calculator website, severancepaycalculator.com, to see what those entitlements are. So middle manager, 9 years of service. I picked an age, let's say 45. Severance calculator correctly says that he's owed more than a year's pay, 12 to 14 months, not weeks, months pay. And he was offered 2 weeks. Now, unfortunately, the Ministry of Labor is only going to be able to get him 8 weeks, so 6 more weeks. So he'll be leaving 10, 12 months of pay on the table. So that's a huge mistake. Don't let that happen to you. If you lost your job, call me. Go to the severancepaycalculator.com website. Call another employment lawyer if you don't like me. That's fine. But can't call the Ministry of Labor, and you certainly can't just accept what's been offered to you.
The frustrating part to this as well is if he's never watched this show, never heard the radio show, he might think, wow, I was offered 2 weeks. Ministry of Labor got me 8. They're rock stars.
Yeah, exactly. Thank God for that.
Yeah.
No, you can't do that. Full entitlements are going to be over a year's pay. Yeah. It's what the law provides. It's not me saying that. It's what the law says. So don't let that happen to you. Don't make that mistake. You need to get legal advice if you lost your job. Full stop.
1-855-821-5900 is the number to get a hold of Lior and the crew. EmploymentHourTV.ca is where you want to go. Find a list of where you can catch our weekly radio show. We play calls from it like we did earlier on the show. I want to get to another one right now.
I've been with my employer for 23 years. I'm still employed there. I had to sign a revised employment agreement a number of years back. Everyone did in our organization. I didn't seek consultation from an employment lawyer at the time. I don't have any concerns about my job or whether I'll be let go. But should that happen, will that dictate then what I'm entitled to, or would I still have the ability to negotiate?
So signing an employment agreement once you already are employed is bad news. Yep. It's almost always a bad news. If your employer comes to you out of the blue, once you're already working, you already have a job, and say, hey, John, sign this employment agreement, they're not doing that usually to help you out.
It's for their benefit, right?
They're not doing that to say, we'll do something better for John. They're saying, we want to do that because it's better for us, for the employer. So what he may have signed is something that limits his severance. So you may not realize that this new employment agreement may cost you tens, maybe even hundreds of thousands of dollars by way of future severance. So I'd want to see that employment agreement to see what it says. I also want to see if he got anything in return for signing the agreement. Arguably, if you already have a job and your employer wants you to sign a new employment agreement, that agreement may not be enforceable. So another important lesson is don't ever assume that just because you sign something, it's necessarily enforceable. It may not be, but be very careful about signing employment agreements once you already have a job.
That number, 1-855-821-5900, employmenthourtv.ca. Still lots more to go here. We'll get to another phone call and what victims of workplace harassment need to do. Very important. Employment Hour 30 continues. Stick around.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30. John Scholes, Lior Samfiru. We also do a radio show several times a week for the past half decade. If you want to find out where you can catch the radio show, employmenthourtv.ca. We take a ton of phone calls. People call in. They want to know things. So we like to play back a few on this show and get your perspective on it. So we'll get to another one.
For 7 years, I was let go without cause after ongoing harassment. Harassment was of 3 people, myself, my subordinate, and my counterpart, and I was terminated because I was a witness. They've paid, I believe, 1.5 weeks for every year work. My age is, I'm 36. I was a pharmacist.
Okay, so let's talk briefly about workplace harassment.
Yeah.
Obviously, if you're, in this case, she wasn't necessarily a victim of harassment, she saw it. But if the employer is concerned that she'll hurt us because maybe she'll give evidence or maybe she'll tell people what we did, and because of that she's fired, it's the same thing. You cannot be let go because your employer was harassing someone. You cannot be let go because you saw something wrong and you stood up for that to fix the problem. That's illegal. So right off the bat, there may be some human rights damages here. There may be issues of bad faith and reprisal. Okay, so beyond severance, there could be other things that this employer may be liable. But let's even stick to the basics. Let's talk about severance. So let's take our information, and as we talked before about the severance calculator, let's go to SeverancePayCalculator.com and let's input that information. So she's a pharmacist. After 7 years of employment at the age of 36, she's owed 6 to 8 months of severance. She was offered 10.5 weeks. Wow. So there's a difference there of some 4 months of pay that they owe her. That's a wrongful dismissal beyond everything else. That's just another example why people should get advice if they lose their job, and certainly go to SeverancePayCalculator.com.
Got a couple minutes to go. I wanted to get into something called TerminationQuestions.com, another resource for you to answer questions. Lior answers them back. A member of his team gets back to you as well. This one, quite simply, I was promised a promotion last year. This year, I didn't get it. In fact, it was given to someone else. I was let go. Can my employer do that?
Well, the reality is your employer can let you go pretty much for any reason. Now, if you were promised a promotion, you're promised more money, when it comes to calculating your severance, we may have to now calculate it on the basis of this higher salary. So if you were making $70,000, your employer promised to increase it to $80,000 and they didn't, and you can show that they promised, your severance may potentially be calculated on the $80,000. So can your employer let you go? Yes. Does that make them a bad person? Probably. But from a legal standpoint, you can be let go if your employer doesn't want to give you a pay raise, but they would have to pay you your full severance and based potentially on the higher salary. Again, reason number 2051, why someone should get advice if they lose their job.
I was going to say, always call you because they need to reach out before it's too late, right?
Absolutely.
There's a time limit on these things.
2 years, and not 2 years in a day, it's 2 years, Johnny.
Going to wrap it for another show. A way to reach out, several different ways. A phone call, of course, 1-855-821-5900, employmenthourtv.ca. And there's also help at employmentlawyer.ca. That is the email source for you. Want to catch the radio show? Go to that website, find out where you can see that and hear that anyway. And of course, always, always, always consult SeverancePayCalculator.com and then make that phone call Don't leave money on the table. Make sure you use it. Again, severancepaycalculator.com. Till next time, Employment Hour in 30. We'll see you again.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.